In this podcast, we talk about the counteroffer. First, we'll talk about the counteroffer, and then we'll discuss the battle of the forms, and then we'll go to the different forms of acceptance. Now, remember that an offer is a communication by the offeror indicating a willingness to enter the contract on certain terms. Acceptance is expression of willingness by the offeree to enter the contract on the terms stated in the offer. There are certain characteristics of acceptance. First of all, there has to be an unqualified commitment to the terms of the agreement that has been offered. So if in response you say, your offer is agreeable, that may not be an unqualified commitment. I would have doubt that you had accepted. I accept your offer would be acceptable. The second is that it has to be assessed objectively. Recall that the reasonable person test is used to determine whether there was an intention to create legal relations. It is the same type of test used to determine whether there has been acceptance. First, the offeree's subjective intention is not determinative. Rather, acceptance is construed on the basis of the reasonable person test. Ask, would the reasonable person, on the basis of the circumstances as a whole, regard the offer as having been accepted? The third is there has to be consensus ad idem. Acceptance must be a mirror image of the offer. And fourth, the acceptance must be in response to the offer. Given these characteristics, let's turn to the counteroffer. When you look at the above principles and you expand them a bit, it takes you to this point. There has to be an unqualified commitment to the terms of the agreement that has been offered, and that affects the counteroffer. When you discuss it in the terms of having to be an unqualified commitment, the rest of the principle is to the terms of the agreement that have been offered. Meaning, if the purported acceptance varies the terms of the offer, it will be treated as the proposal of new terms and classified as a counteroffer, not an acceptance. The effect of the counteroffer is that it removes the initial offer from the bargaining table. A counteroffer kills the original offer and makes a new one. Now, the general rule about counteroffers has some pretty harsh consequences. And so the courts have responded in interesting ways. First, they could construe the offeree's responding statement as a statement of inquiry rather than the counteroffer. Because remember, the minute you find something to be a counteroffer, the original offer is off the table. It can no longer be accepted. The second thing courts may do is they may find that mere restatements of the offer with minimal or trivial changes or with addition of meaningless terms will not prevent effective acceptance. Third, they could see if the offeror signaled in his rejection of the counteroffer an interest in continuing negotiations, which you'll see in the next case of Livingston and Evans. In Livingston and Evans, the defendant Evans wrote to the plaintiff Livingston through his agent offering to sell the plaintiff his land for $1,800. When Livingston received the offer, he sent a telegram in reply which stated, quote, "Send lowest cash price. Will give $1,600 cash." The agent for the defendant replied by telegram, "Cannot reduce price." Immediately upon receiving the telegram, the plaintiff replied by purporting to accept the offer to sell at $1,800. The defendant conceded that his initial offer and Livingston's acceptance would amount to a contract unless the intervening telegram put an end to his offer. If the telegram put an end to his offer, then the plaintiff could not bind the defendant to the offer by accepting it. Which takes us to the issue of whether counteroffer is a rejection of the offer. And the ratio is the making of a counteroffer is a rejection of the original offer. The reasons were that the plaintiff's telegram was definitely a counteroffer. It thereby ended the defendant's offer unless it was revived by a reply. The defendant replied to the plaintiff's counteroffer. Now, the reply was there's a question about the reply. First, was it a rejection of the plaintiff's counteroffer? Or did it renew the original offer and give the plaintiff the right to bind the defendant by accepting it? The statement "cannot reduce price" indicated a willingness to stand by the initial offer. So the court found that it was still open for acceptance. And in the decision, you see obiter, which is a mere inquiry to an offer, is not treated as a rejection. And it's obiter because it was not the issue in the case. So given those principles about counteroffers, we now embark on what is known as the Battle of the Forms. So what is the Battle of the Forms? This is where parties are entering into agreements and purporting to do so on the basis of their own standard terms. So for example, let's say a buyer places an order for goods. The buyer uses its own standard form. The form states the terms and conditions on the back. The order is then accepted by the seller on the basis of a standard acknowledgement form that states the seller's terms. The seller's terms may be repeated on a delivery notice or an invoice, and the buyer's terms may be repeated in a form acknowledging delivery. Often it is the case that neither party has agreed to the forms being utilized by the other party. If there is a problem, the issue becomes which party's terms are to prevail. And this creates the Battle of the Forms. Why are standard forms used? We'll see a lot of reference to standard forms as the year progresses. Why are they used? For commercial convenience, simply. It's too expensive and difficult for businesses to negotiate a new contract for every transaction. But the Battle of the Forms is an example of the tension existing between those trying to adhere to traditional contract principles and the reality of commercial transactions. So traditional contract principles are what we just discussed. There's no contract unless there's a meeting of the minds. There must be an intention to accept the entire offer. Then if we apply the rule about counteroffer to each successive form, the problem is, on the basis of all the forms exchanged, the parties have failed to create an agreement. So if you apply traditional contract principles, whenever these problems arise, you will always find there has been no agreement created. The commercial reality, though, often demands recognition of the contract because there has usually been part performance by the time things get to court. And as is always the case, if you find there was never a contract when the parties have already been performing, it could be devastating to the parties. There has been a lot of reliance, time, energy, and money spent already in performing the contract. So the question becomes, should the law conform to business or should business conform to law? And that question arises under a lot of different topics that we will come back to. Now, there have been several means for resolving the Battle of the Forms. One of them is you can stick to traditional contract principles, the mirror image rule. This is a legal principle. You need consensus ad idem, meaning if there's no consensus ad idem, there's no agreement in the end. You can look at unjust enrichment. So we just spoke about how contracts are usually partially performed when this issue arises. To find that there is no contract may mean a loss of a lot of money for either or both sides. If you look at it as an unjust enrichment issue, then you'll look at what is the enrichment to one party. It is at the expense of the other as a result of an unjust factor. So the unjust factor could be mistake, it could be compulsion, it could be incapacity. And if you find the test that for unjust enrichment has been met, then the party who has been enriched must give back to the other party the value of the enrichment. But no contract terms would be enforced. So that's another way of dealing with the Battle of the Forms. The next two methods that we'll talk about are not legal principles. They are factual conclusions the court reaches after considering the context of the transaction. So the first shot doctrine is where it's the first document that governs and subsequent terms are irrelevant unless they're highlighted. And the last shot doctrine means that if the last form utilized is followed by conduct that may be considered to constitute acceptance of the form contained on that form, rather acceptance of the offer contained on that form, then an agreement will be created. So the party who fires the last document before performance prevails, or put another way, a contract is created by a series of conflicting forms only when the last form is utilized and followed by conduct amounting to acceptance of the counteroffer, then the agreement is governed by the last form. So those are the different ways that we can deal with the battle of the forms. And you see that in Butler Machine Tool. Butler Machine Tool, the defendant buyer wanted to buy equipment from the plaintiff seller. The plaintiff seller sent a document that quoted the price of approximately £75,000 within delivery in 10 months. Written on the back of the form was a statement that said that the price was to be the price at the delivery date. This price escalation clause meant that although the price was stated to be £75,000, it would be increased if, before the delivery, the plaintiff's own costs increased. Also on the back of the form was a statement that the sale was subject to the plaintiff's standard terms. The defendant buyer received the document and replied with its own form purporting to accept. The defendant's form stated that defendant's terms were to prevail over the plaintiff's. The form did not mention the price escalation clause. The form included a tear-off strip to be signed and returned by the plaintiff, which stated that the plaintiff accepted the contract on the defendant's terms. The plaintiff did sign and return the defendant's strip, and at the same time sent an accompanying letter that reiterated the original price of £75,000. However, there was no reference in the letter to the price escalation clause. The plaintiff delivered the machine, later demanded an additional £2,800 as reflecting the current market value, and in response, the defendant said that the price escalation clause was not part of the contract. The issue was the contract completed on the defendant's terms, the plaintiff's terms, or neither? And the ratio is, there are various means of resolving the battle of the forms. The majority went with the traditional mirror image rule. The seller sent a quote in response to the buyer's inquiry. The quote incorporated the seller's printed terms. Then the buyer sent in an order incorporating his own terms with a tear-off acknowledgement to be signed and returned by the seller. It said, quote, "We accept your order on the terms and conditions stated therein." The seller signed and returned the form with a covering letter referring to its earlier quotation. And the court found, given all these transactions, the buyer's purchase order was a counteroffer that killed the seller's earlier offer of sale, and the seller's return of the tear-off slip constituted acceptance of the buyer's counteroffer, which means the contract does not include the price escalation clause. Lord Denning came to the same conclusion, but on different grounds, so he concurred. But he said that courts have a strong desire to find a contract in the battle of the forms, especially if the contract has been executed, meaning performed. And there are three non-traditional ways to resolve the battle of the forms. One, the last shot wins, which is basically what the court above did, or what they talked about. They also talked about the first shot winning. But he said there's also a way of reconciling the shots, which he prefers. And he said the terms of the parties should be construed together. If they can be reconciled so as to give a harmonious result, then all is good. If the differences are irreconcilable, so they're mutually contradictory, then the conflicting terms must be scrapped and replaced with a reasonable implication. Now, the documents as a whole indicate the contract does not include the price escalation clause. Now, they all came to the same conclusion, but Denning's approach is more consistent with the reasonable expectations of parties, and it is more conciliatory. And that's important because in a lot of these cases, these are parties who may want to build lasting business relationships. So instead of the majority's approach, who treat the parties as though they're at war, Denning's approach is a bit more conciliatory. The next case is called Tywood Industries and St. Anne Nakawik. In this case, the defendant buyer had initially issued a tender call that set forth various terms and conditions, none of which included an arbitration clause. The plaintiff seller's bid in a letter form that contained on the back a detailed list of the seller's terms and conditions that did not include the price escalation, the arbitration clause. And then in the purchase order next issued by the defendant buyer, the terms did include this clause. On the face of the document, the order said to be accepted by the seller subject to the terms and conditions on the reverse side, and the seller was instructed to send a, quote, acceptance copy of the order promptly to the buyer. The seller did not execute or return a copy of the purchase order to the buyer, and the contract was performed. The seller sent the goods, but the defendant buyer refused to pay. So which terms prevail? And the ratio here was that sometimes it is the first shot. So here, the arbitration clause is inapplicable. The court talks about the strong judicial desire to find a valid contract if the contract has been executed. But here the plaintiff seller did not put his mind to arbitration at all. The plaintiff didn't acknowledge the supremacy of the defendant's terms. The defendant did not draw particular attention to that term, nor did it complain when the plaintiff failed to return the vendor's copy of the purchase order with an acknowledgement of the terms now sought to be imposed. The conduct of the parties indicates neither party considered any term other than those found on the face of the documents. In Canada, all provinces and the federal government have made the United Nations Convention on Contracts for the International Sale of Goods, which is the Vienna Sales Convention, part of the law in Canada. This legislation applies to all international contracts for the sale of goods unless the parties have expressly excluded the operation of the convention. And if you look at the terms of this, it talks about the Battle of the Forms. So I'm not going to go through it, but go ahead and read it. And it basically tries to consider all of the differing ways that we've talked about and how to come to a conciliatory conclusion with the Battle of the Forms. Most importantly in this is that if the parties expressly exclude this convention in their contract, then it will not apply.